experts believe the stress of divorce is second only to the death of a spouse. For most people, divorce marks the end of a relationship that was intended to last a lifetime. In this edition of Pro Se Nation, we're going to explore a number of ways to lessen the anguish and the stress of divorce and empower individuals to go their separate ways with grace and dignity. I'm Mary Lynn Chiave, and welcome. Joining in the discussion is Anju Jessani, Alan Carmen, and Marianne Bauer. Anju Jessani is a mediator who established Divorce with Dignity mediation services in 1997 with offices in Clinton and Hoboken, New Jersey. Ms. Jessani served as president of the New Jersey Association of Professional Mediators from 2005 to 2007 and as a board member for a decade beginning in 2000. Alan Carmen is the author of The Measure of a Man and the principal of Carmen Paralegal and Mediation Services in Scotch Plains, New Jersey, specializing in family law. He is an adjunct professor at Union County College. Also joining the discussion is Marianne Bauer, a certified matrimonial attorney based in Hunterdon County, New Jersey. Ms. Bauer specializes in divorce, custody, and domestic violence issues and is a trained collaborative law attorney as well as a mediator and arbitrator. What is the biggest mistake that most people make when they are about to enter into the divorce process?
I think coming to the process as an uneducated consumer is the biggest mistake that they make. It's very important that they learn the alternatives that are available to them. It's very important that the potential client learn a little bit about the issues that they'll be facing.
I think people need to stop watching television when it comes to divorce. They oftentimes have this idea that if I file the complaint, magic will happen. And in fact, oftentimes filing a complaint, especially prematurely, before you understand your options, as Marianne is saying, can really create problems. That complaint for divorce often signifies the end date of the marriage as far as things like equitable distribution. It may not be in your best interest to be filing the complaint. And the other part of that is the complaint just starts the divorce process, but you need to still come to a settlement on your parenting issues, on your division of assets and support. So it cures nothing, and it often creates problems. So an educated consumer who understands how divorce works, understands the different alternatives in divorce, mediation, collaborative law, litigation, comes more educated, more able to negotiate.
Alan?
I think that the divorce process is a very emotional process. However, the mistake people make is bringing the emotions into the process. And I know that sounds silly, but if you can somehow remove part of the emotional part of it out and think of it like you're ending a business deal, it makes the process easier. What happens is when the emotions start to take on a life of their own, then the process gets to be very confrontational and there's a lot of conflict. And it makes the process that much more difficult.
There are three components to every divorce. There's the legal component, there's the financial component, and there's the emotional component. And it's very important to pay attention to all three of those. And Alan, you are correct that often the emotional component goes unchecked, and that has a tendency to drive the case.
And you end up with War of the Roses.
Correct.
Where ultimately, sadly, both parties lose. And in that case, I mean, that was a black comedy. They both died, but under the chandelier. Mediation is a dispute resolution process in which an impartial third party, the mediator, facilitates negotiations among the parties to help them reach a mutually acceptable settlement. The major distinction between mediation and arbitration is that, unlike an arbitrator, a mediator does not make a decision about the outcome of the case. Generally in this state, and I think in many states, mediation is mandatory once you file any kind of a lawsuit. And generally it takes place sometime in maybe in the first 6 months. Does it make sense in terms of the divorce process to bring a mediator in before you actually file suit?
Absolutely. I've seen a trend lately, and it's a positive move, in that we attempt to negotiate a settlement before we file a divorce complaint. So the goal of every divorce is to negotiate a successful marital settlement agreement. And you can do that through, as Anju said, mediation, collaboration. Arbitration is a different process. Mm-hmm. However, all efforts should be made to do so before entering the court system. Because once you enter the court system, you really lose control over the timing of your case and many aspects. And when someone looks at a complaint and it says so-and-so versus so-and-so, that sets the tone for an adversarial proceeding.
Many of my clients come while they're still living in the same home, and oftentimes they haven't hired attorneys and they're very cooperative and they want to work out an agreement together. They want to do that for their own sake, for the sake of their children, for the sake of their friends. And so there's this spirit of cooperation that is really becoming more pervasive. But now this is, first of all, a court-ordered event. But because it's court-ordered, why not come at the beginning of the process? Why go through litigation? Why go through filing complaints, going through discovery, and then come to mediation? We can do mediation in terms of sharing documents by putting them on the table. We don't have to go through discovery. So this is less expensive, it's quicker, it's kinder. I have evening appointments. People don't need to necessarily take days off from work to sit in a courtroom where they may not get heard. And but not everyone can mediate. There is a continuum of services that are provided, and so I'd say I probably have the nicest of the clients. It doesn't mean that it's a love fest, but my clients are able to sit in the same room together, and if they may not be friends, but they're friendly.
Ellen, what has your experience been?
I think the majority of the time, people don't realize that it's probably easier and, more importantly, financially beneficial to mediate or come to an agreement first. And the majority of the time, especially with clients I've had, believe it or not, even though they've litigated, they actually came to the same agreement that they would have come to if they had just come to that agreement before. They were really close, or they had actually been in agreement, but then something happened, something was said, the emotions ran amok, and then all of a sudden they're litigating, and in the very end they're right back to where they were when they first started, and they agreed on those issues. So I think that people take it for granted. They think mediation is not something that they think is a very common thing, but now it's court ordered, so it is more common than people realize. But they don't think of it as the first plan of attack. Instead, right away they're getting their lawyers, they're making phone calls, they're making complaints, and then all of a sudden they're running up a huge legal bill and they're saying, why did this have to happen, when they're going to come to the same decisions they would have come to before that even happened. So I think that people need to realize that this is an avenue they can take to start out, and most times it's going to end up in that same conclusion anyway.
Right. Well, I think what you said earlier about it, if people could keep a cool enough head and look at it as any other kind of ending, the ending of a business or the ending of some other kind of, partnership. Unfortunately, this is probably the most emotional kind of legal situation you can be in. Do you think, or not really?
No, I do believe it is probably one of the most emotional areas of law.
Okay. You know, so when you say, you know, if you can take the emotion out of it, but this is something that is, you know, it's like, well, don't take it personally, but I want to divorce you, right? I mean, you know, it's hard not to take it personally.
One of the things, and I've said this to a number of clients who will call me up making complaints about, and one of the biggest mistakes they make is they listen to someone else who is also getting divorced, and it becomes a misery loves company type of thing, and they try to relate what they're going through to someone else. Well, why didn't the judge give me this? Why didn't I get that? And that's what I always say, you know what? You have to take the emotion out of it. And they always come back with, what do you mean take the emotion out of it?
Right.
But the fact is that what drives the litigation is the emotion, the emotional part, that segment of it, because the finances can be worked out, the legal work can be worked out. It's the emotional part, and it's most of the time it happens when one of the parties is all of a sudden involved with someone else, and a third party is involved. And I always call that, you know, third party intervention. And all of a sudden things go awry because the concentration is on what's going on with that other party. If the emotional part could just be taken out of it, and it could be made to be as much like a business deal as possible, a lot of the confrontation would be out of it. Everything would move a lot quicker. And then people's biggest concern, paying legal bills, it wouldn't be as painful.
Right.
But it's difficult for people to do that without the assistance of a professional, which is why I love the collaborative process. We very often use divorce coaches in the collaborative process. And the role of the divorce coach is to help the parties understand the emotions of the process and to communicate on a different level. And when they learn to communicate, it's amazing that you'll just see much less post-judgment work. So once they're able to communicate in a more productive way, treat each other respectfully, that gives them a skill set for later problem solving.
They may even decide not to get divorced, right?
That's a possibility. We've seen those cases.
Well, I'd say this, like when my clients come through a referral from a marriage counselor and they've done work with family therapy or counseling before they've come to mediation, they've really mourned the death of the marriage in that process, and they're ready to address their issues. The sad thing when you're getting divorced, it's like a death, but no one brings you casseroles, right? You know, people aren't giving you that same type of support, and oftentimes people are not in connection with their emotions that they're hurting. So they hire an attorney, but they use that attorney as a therapist. And so what Marian is saying is to get the support from the right place, because your attorney is not your therapist. The judge is not going to award you the children 100% of the time because your husband cheated on you. These are things that in a fantasy you might believe happens, but that's not how family court works in New Jersey. And so people oftentimes when they listen to the Greek chorus, or they watch television, they see decisions being made quickly, judges making unilateral decisions. You know, if they watch movies, they have the Parent Trap, right, where people reconcile. These are fantasies. But the reality is that at the end of the day, it's going to take a long time to get divorced through the court process. People will spend a lot of money, but it's going to happen. You're not going to stop a divorce in New Jersey.
Well, I sort of wonder how many people, how many of the general public, members of the general public really understand that mediation is an option before filing a divorce.
Unfortunately, I don't think that enough people are aware of the alternatives that are available, you know, such as mediation, collaborative law, or arbitration. I also don't think that enough people are aware of the fact that if you're able to resolve your matter and sign a marital settlement agreement, you then go to an attorney who files a complaint and you're classified as an uncontested divorce as opposed to a contested divorce. In an uncontested divorce, many courts will process those on the papers, as we say, or they will sign a judgment of divorce without the parties ever having to step foot in the courthouse, which is a great financial and emotional savings.
Right.
I'm going to say that the internet has changed everything. And So nowadays, consumers don't have to go to law libraries to get information. And I'm finding that the clients who come to me are educated consumers. So I'm fortunate in that because I'm not spending a lot of time on the phone explaining what mediation is anymore. When I first started my practice, every call would be explaining that my role as a mediator is to facilitate a resolution between two parties. But people have read the Mediation Association's website, they've read my information, they've read my colleagues, because, you know, clearly they're kind of making a short list of 3 mediators we're going to call. And I'm amazed at how bright and how educated they are, and they have it right. They're not saying to you, you're going to make a decision. They're saying, okay, you're going to help us get through this, and, you know, we'll bring the information, and it's our decision making. So before the internet, it was a whole different ballgame. I think that the internet and this idea of self-determination, I mean, people have Schwab accounts. People want to have self-directed investments. People want to have a self-directed divorce.
Marianne, you're an expert in collaborative law, and can you explain how that's different?
Sure. Collaborative law differs in that it's a team approach. So each party is represented by an attorney, so they have the benefit of legal advice as the collaborative process is moving along. You add other team members, for example, a coach or a financial specialist to for, I like to say, for diversity thinking, which is a new term that I learned this week. And it differs from mediation in that we sign an agreement that we're not going to litigate, and we're working toward a marital settlement agreement. In mediation, the parties still need individual attorneys because the mediator neutral is not able to give legal advice.
Right.
I do a lot of mediations where I include attorneys in the mediation process, and I'm having 5-way meetings with the clients and the attorneys together. It doesn't look that different, except we're not signing an agreement that if things fall apart, that the clients can't litigate. Whereas with collaborative law, they are signing a collaborative agreement that they won't take this to trial.
Right. I think that the difference is when you bring the third party to the process. The third party is someone with a different skill set, not to assist in the negotiating, because you're not really negotiating in collaborative. In collaborative, it's the job of the attorneys to assist in presenting options so that the parties may decide which option works best for their family.
What about the aspect of prenuptial agreements? Does it make the divorce process easier? Does it change it in any way?
Prenuptial agreements are great, but it can also, they can be thrown out depending on what the situation was, and circumstances change. I mean, during the course of a marriage, circumstances could change the meaning or what the purpose was, you know, intended, so that it may not even be, you know, of value. However, hypothetically, it should make things easier.
Well, they're really intended to govern 2 different eventualities. One is a divorce, and the other one is the death of a spouse.
Right.
So we often see them in second marriages to protect children from a first marriage.
Okay.
The problem with the prenup, and the ones I've seen, is oftentimes they're done at the 11th hour. You know, the wedding plans are made. They already had the, you know, whatever, rehearsal dinner.
Like Private Benjamin. Do I watch too much TV and film?
Yeah, and the husband is saying, you know, well, I can't get married without this, and the wife says, well, you know, and I'm just saying that in most of the cases I've seen, it's the husband who has the assets, who has who might have larger earnings, and the challenge is with the Uniform Prenuptial Act, you're both supposed to have attorneys. There's supposed to be discovery. You're not supposed to have this duress of the pressure of an event that's coming up around the corner. Oftentimes, how they're constructed presents a problem. But at the same time, I mediate a lot of prenups within the people do hire attorneys as well. And it's a very good process to talk about how we want to manage money in a second marriage.
We're seeing more and more prenups because of second marriages. The most famous case in New Jersey, it's reported, was when John DeLorean presented the prenuptial agreement to Christina Ferrara the evening before they were married. And that was held to be an invalid prenuptial agreement.
I'd really like to get to how you feel about people who want to go pro se or self-represent in divorce proceedings. Alan, I think you've had some experience with that. Would you like to address that?
I do have experience in that. That's actually how I ended up doing what I'm doing, from working on my own case. But I had to educate myself, and I did that by observing and making sure I knew what I was looking at as far as documents. I spent a lot of time in courtrooms. I spent a lot of time talking to different attorneys, who were willing to, guide me. And I sought out a lot of support groups that were educated prior. So I learned a lot. But what I will tell you is that as much as I'm an advocate of doing pro se work, I think that having the guidance of an attorney is very important. I've done it both ways, and I think that at times, whereas I personally am very comfortable litigating, and I've been in front of a judge, and I have great confidence in doing my own litigating, I've also felt overwhelmed at times, and I've watched other people who are not comfortable in front of a judge. And I think that when the time comes when you have to do oral argument, I can't say it enough that it's important to have a professional, because when you're doing oral argument, there are so many things that can go wrong, and your life is in the judge's hands. And to do it without a professional, when you don't know what you're doing, that's problematic. And then when the results are not what you want them to be, then you're upset about it. But if you use a professional when you really need them, then at least you have that guidance to go by.
Right. I went pro se in a case that I was involved in at times, and I have to say the first time I went before the judge, it was probably the scariest moment of my life. One of the most frightening moments. It's a very intimidating environment if you're not in that inner circle, which is to be a legal professional.
Well, I know lawyers who are very powerful looking figures who literally freeze up in front of a judge. It takes a special kind of person to, number one, remain confident, gather all their thoughts, and be able to spew the information that they had in their head and get it out the right way and present it the way it needs to be presented. So then if you have someone who is not an attorney, who doesn't know how to get up in front of a person and present legal aspects of a case, and they're fighting for their life and their children's lives, it is very problematic in the fact that they are in a position that they shouldn't really be in. So whereas some people can do the work pro se, and Marianne has said earlier that a lot of cases are done on the papers where you never are in front of a judge and you're never entering a courtroom, you can't rely on the fact that you won't be standing in front of a judge. So to put yourself at that kind of risk sometimes is not advantageous. It's more advantageous to have a professional guide you through the process.
And Anju?
Well, I see a different subset of people. They're not interested in litigating. They want to do their own divorce. The challenge with their own divorce is they really don't know the rules of the road. And so they're likely to miss something. Typically, they're going to miss the fact that a pension is divisible in a divorce, and how that gets divided, usually through a qualified domestic relations order. So they're coming in with their own notions of how the law should work, or how assets should get divided, or what belongs in the marital pot and what doesn't. For instance, an inherited asset that if you kept separately doesn't become part of that pot to divide. But oftentimes, either they don't know that, or the person who knows it, if it's not to their advantage, ignores that information. So having a neutral third party helps with that. And I tell them they're going to have to live with this agreement a long time. Hiring separate attorneys to review an agreement that either they put together or is put together in mediation is money well spent. We're not spending thousands of dollars litigating, but again, you're going to have to live with this agreement a long time. It's like constructing a house with a bad foundation. To repair that later is going to be very expensive.
Marianne?
Yes, there are many instances where a party is able to be pro se or self-represented. For example, there are forms online at the New Jersey Judiciary website. If it's an issue of child support, there are forms that can be completed so that when you appear in front of a child support hearing officer, you're able to gain that relief. However, I agree with my colleagues that an attorney plays an important role, and certainly if you had a toothache, you wouldn't try and remedy that yourself. So I think the importance is gauging how complex the issue is and whether or not you're able to navigate the system as a self-represented person.
Somebody's approaching divorce, what would you tell them? What's important?
I would tell them to read Crazy Time by Abigail Trafford, to look forward, to know that it will be okay, and to take their time, do their homework, talk to different professionals, take a deep breath, go to a support group, hire a therapist, and decide what you really need.
Alan?
Just very simply, I know I said a couple times about taking the emotions out of it, and obviously you can't totally do that, but I think the most important thing is not to let your emotions dictate where you go.
Again, I would say come to the process as an educated consumer. Do a little internet research. Meet with an attorney or several attorneys so that you know what your options are and that you choose your process wisely, and gather a little bit of information about the issues that come up in a divorce. Typically, the cause of action, custody, child support, alimony, equitable distribution.
And maybe the lesson in all of this is that couples should seek out a mediator before they get married, right? Or some kind of neutral party to kind of work through how, after the blush of romance has
I like pre-Cana. I like what the Catholics do with pre-Cana, because they ask some very important questions. How many children do we want? I mean, we all see clients where people have this expectation that I was going to have a large family, and then after we got married, she told me she didn't want children.
Right.
So that pre-Cana, it puts
sometimes
those
you
issues.
wonder what they were all talking about initially, right?
Well, I believe that every marriage fails for an inability to communicate. What is the issue that you can't communicate about? Is it children? Is it money? Is it in-laws?
Okay. Well, thank you so much. And thank you for joining us for this edition of Pro Se Nation. If you would like to be a guest on the show, or you have any ideas for future topics, please contact us through the website. That's prosenation.org. I'm Mary Lynn Shiabi, and see you in the future.